We never read the modern one. The language.
All right, welcome back. Sorry, a little delayed. I think this thing turned on and on now. Please sign in for attendance again. If you are watching this at home, you can email me to certify your attendance, but you should all be here. You have no excuse. All right. Please mark your attendance in for this session. I'm activating it. Okay, there we go. You'll be able to sign in. All right, so please sign in for your attendance. It's been 30 minutes since I last saw you, but I think you'll transition well. I want to start you off. We're going to do the case in order. I want to first do the Spelunking Explorers case, and then I'll do the Pierson v. Post case. And I want to poll you first. I asked you about this in advance, about which justice you agree with. This is not multiple choice. This should be asking to enter in a number. Please enter 1, 2, 3, 4, 5, 6. I want all of you to vote. I want to see how you understood the Spelunking Explorers case. And I'm going to poll you again at the end of class to see if the numbers changed at all. Sometimes they do, sometimes they don't. So you know 30 seconds or so. All right, many of you haven't voted yet. Is there a reason? Okay. All right, so I'm going to put this off to the side now. If you haven't been able to do it yet, you'll do it a little bit later. So first off, why did I assign this? Right? Why did I give you this case, which is ostensibly about criminal law, but in a property class? The reason why I gave you this essay to read, and this is famous, law students have been reading this for decades, is to give you insights into how different judges resolve different types of problems. Well, there are really 5 judges, but the 6 different opinions that I have you read probably summarize virtually every single opinion you will read in law school. The sorts of arguments advanced here are so common that after you read this article, you say, oh, wow, that's what Judge so-and-so did, and that's what Judge so-and-so did, right? This article is a legend because it summarizes how judges approach cases. It does so in a very exaggerated fashion, right? Very exaggerated, where the judges say things that you've probably never seen in an opinion. But it's done quite deliberately to illustrate the various means by which judges think. So what I want to do is walk through the facts of this case. It's a fake case, I'm sure you all know this, right? It's not real. It's based on a real case, which you may have read. I want to walk through the facts of this fake case, and then go into Pierson v. Post, and draw comparisons with how the court in Pierson ruled based on how the court with the Spelunking case ruled. And I think you'll be pleasantly surprised at how similar the modalities of thinking are. Okay? Okay, who was last off last class? Josh? All right, Matt, you want to give us the facts, please?
So, there's, I guess, 8 explorers.
Yes, spelunking is people who hike in caves, but yes, very good.
So they're
Good.
There's a, I guess, a rock slide, a cave kind of.
Okay.
And so they're trapped.
They're trapped.
With apparently no resources or not enough resources, they eventually have to kill somebody.
Whoa, you're jumping way ahead, right? Let's walk through this slowly, right? So you have 4 hikers plus Wetmore. And they go to a cave. There's a landslide. Boulders block the access to the cave, it's the only opening. They notify the family and they dispatch a rescue party. They note that during the rescue, over 10 people were killed. This is a very dangerous rescue. No one cares about the one guy who was, everyone cares about the one guy who was eaten, right? No one cares about the people who killed rescuing them. I think about those. Whenever you see like these people go hiking in the middle of the snow and they get trapped and like 2 people die trying to rescue them, why were you hiking in the first place? That's an outlier. So money was collected trying to rescue them, they couldn't. So they were stuck there for almost a month. They had limited food, they had limited water. They didn't have a radio. Okay? So Joey, what were some of the questions they asked over the radio?
They first talked to some physicians
Yeah.
to see how long, what the estimated time of rescue was. The physician said it's 10 days.
Yeah.
They asked if they would be able to sustain life for 10 days without food, and the physician said it's highly unlikely.
Yeah.
So then they asked if the physician would recommend eating one of the people trapped in the cave.
Yeah.
And the doctors didn't want to say yes or no, so they kind of balked. So they asked to speak to some judges to see what their legal ramifications would be.
Yeah.
Through lots and
Well, before we get to the lots, what did the judges tell them? What did the government people tell them?
they didn't believe they could.
They didn't give any advice, did they?
Yeah, and they balked it.
And then who else was asked? Who else did they ask to talk to? They asked if the judge or government official could comment. Who else did they want to talk to?
I thought it was just the doctor and
Yeah, Jenica?
That was the priest or minister.
Yeah, they want to talk to a priest. So in other words, can we get some salvation from God before we do something really, really bad? Okay. And was any priest found, Jenica?
No.
No priest was to be found. Okay. And after that, the radio went silent. They assumed the battery died. That wasn't the case. So the 23rd day, they had this idea. Costa, what was their idea on the 23rd day?
To kind of, Whitmore had dice,
Good. And what were they going to do with the dice?
kind of determine who the short
Yeah, who threw the one, right? So Whitmore, again, Whitmore's the guy who gets eaten, right? Whitmore comes up with this genius idea. I got it. How do we decide who to kill? We throw a dice. Whoever throws the lowest number is dinner, right? Something like that. Okay, so this was Whitmore's idea. Okay. What happened before they threw dice, Augusta? Before they threw it, what happened?
Was it just silence on the radio?
No, but within the dice game, right before the dice were thrown, what happened?
Oh, they talked about possibly delay.
Yeah, it's like about withdrawing from the agreement, right? Eventually they decided not to. Whitmore's turn, he had no objection to the fairness. He threw the lowest number. He was put to death and eaten by his companions. They were then rescued about 9 days later. They went to the hospital. After they recuperated, they were indicted for murder. Now, I want to pause very briefly. Samta, why were charges even brought in this case in the first place? Did a prosecutor have to charge this?
I mean, the prosecutor does not have to, however, they did kill him.
So I want you to keep in mind, right or wrong, the decision to bring the charge in the first place was an important decision. They didn't have to, right? You don't have to bring a decision. All right, so Samta, keep going. After charges were brought, what happened next?
wasn't a verdict, it went to the court,
What?
yeah, it went to, the court, and I guess they set it aside, I'm not sure.
Well, what happened in the court? How are criminal prosecutions usually handled?
Well, first you have to, make sure that the people you're charging meets, each element,
Okay,
or
good, so they were
have
indicted. What hap-
sufficient to each element.
Okay, then what happens?
And then, the court or jury will be assembled, I guess.
Good.
To decide the case.
Good, okay, so then what happens after the jury is assembled?
The judge would instruct the jury on how to rule in a particular case.
What happened here? It's a little bit unusual.
Right, they didn't have a jury.
Oh, they didn't?
Or, I don't remember reading about them having a jury. I believe that there was a public opinion.
No, there's a jury. Caitlin, what happened with the jury here? Something a little bit unusual. No. What did the jury ask for? They asked for something very specific.
Special verdict.
No, I'm not asking. I'm asking her. Just don't talk out of turn. Yeah. Yes. Okay. They wanted. Now, what's a special verdict, Caitlin?
That they be charged and then like the charges are dismissed by someone else.
No. Nikisha, what's a special verdict? Yeah. With a special verdict, the jury finds the facts. But the judge decides based on the facts if there's guilt or innocence. Alright? These exist, they're rare, but they're possible. Okay? The court agreed to it, which was surprising. Usually judges don't like these, it makes more work for them. Based on the special verdict, the judge found them guilty as charged of the crime of murder. There's only one sentence, there's no discretion, hanging. The jurors told the chief executives, like the president, that we want that they hope the sentence would be commuted in 6 months. Maybe it would, maybe it wouldn't be. The chief executive was waiting for the court to rule. Okay. So what follows then is an appeal of the conviction to the Supreme Court, was it Newgarth? This is a fictional world at some point in the very distant future. It's deliberately designed to be very far in the future so that it's nothing like our society. And in fact, the author made a point of saying, don't even try to figure out which judges I'm talking about, you won't. People will try anyway. Okay? So what I want to do is go through the various opinions of each of the 5 judges and discuss the ways which they reach their opinion. Okay? So, who's next? All right, Reed. Walk me through Justice Truepenny's opinion. It's really short. He's just the shortest one of the entire lot, I think.
So he's basically saying you look at the statute and how it's worded and you put aside any personal views.
Yeah, talk louder. I can't hear you, please.
You look at the statute, the way it's worded, and put aside any personal views. So if they committed what the statute says they committed, then they're guilty regardless of how you feel personally.
Okay, very good.
And then he goes into what he views the chief executive should do.
Ah, good. Okay. So you gave me 2 things that are very good. Let's split them in half, right? The first thing, Judge Truepenny, his analysis is just follow the statute. Right? Follow the statute. If they committed murder, they committed murder. It doesn't matter what our sympathies are. There are no exceptions to the statute. The second part of his opinion, which is a little bit strange, I haven't seen this in an opinion in law school yet. He says that the chief executive, I guess it's like the president, should pardon or commute the sentence. That is, the chief executive should, cancel the hanging. Right? Should a judge be in the business of asking for clemency from the president, from the chief executive?
Ideally, no, because that goes
beyond their powers.
Why? Why can't a judge ask for clemency?
I mean, you can personally, but the job of the judge is just to interpret the law and render a verdict. The judicial system is separate from the executive system.
So Ryan, let me ask you a follow-up. If he's so convinced that equity warrants that the hanging be stopped, why wouldn't he just join one of the other opinions that was able to find an exception to the statute for murder?
Because he doesn't believe that that's what justice requires, because his job requires him to interpret the law based on the law.
But he has a funny interpretation of his job if he's basically begging for clemency from the executive.
Right.
Right? So everyone see the tension, right? On the one hand, he's like straight down the books. Follow the law. Follow the rules. No exceptions, right? And then like in the very next paragraph, he says, well, but, you know, while we're at it, I'm writing an opinion here for the court, Chief Justice, right? And, you know, I'm going to make my plea to the chief executive to give off a clemency. Mind you, he's doing this on taxpayer dollars, right? And government printing, right? This is a legitimate grievance that he's using government resources to lobby the other branches of government. Do we ever see judges do this? You're shaking your head. No, you're wrong. Anyone have an example? You have an example? Yeah, you want to try, Andrew?
I was going to say the one you talked about on the radio with the federal judge in San Francisco.
Oh, good memory. Yeah. What's an example I was thinking of, but I'll mention it. Actually, it's a bad example, but very often when the Supreme Court has a case and say a statute is read in a certain way, that seems a very unfair result. The Supreme Court will say, well, it's not for us to fix it, it's for Congress to fix it. Right? Let Congress amend the statute, not for us to fix. And you very often see that. The one that Andrew mentioned, which is a little bit different, there was a recent case where a judge issued a ruling to the government to produce some documents. The government said no, they filed an appeal to the Supreme Court. And then this judge filed an appeal filed his own brief to the Supreme Court. Very unorthodox, very unusual. I'd never seen this in my life, that a judge files a brief in his own case for the U.S. Supreme Court. He lost, reversed, unanimously. But that's not the point. But very, very, very astute radio listening. Okay? So that's Judge Truepen, right? Jake, Judge Foster had two separate opinions, which were completely incoherent, right? Neither one did one to the other. So let's just do what I call Foster 1, the first part of Foster's opinion. What's his analysis here?
He thought it should be set aside based off of if the statute shouldn't be read so direct because common sense, reasoning is based on the circumstantial situation.
Why did the statute not apply to the people stuck in this cave? What's his rationale?
That it would raise the question of fidelity to the natural law. That basically, I guess it wouldn't you have to read between the lines, basically, is what he's saying.
Name card?
Oh, I don't have mine today. It's Ashton.
Ashton. Okay, Ashton. Why does Foster think that the statute is simply inapplicable to the defendants in the cave?
Didn't we talk about, didn't we bring up the law of nature?
We're off the law of nature. What's this law of nature business? Where did we discuss it before?
So it talks about how so he talks about men's coexistence together and how
where we talk about the law of nature, we're going to have one other class so far this semester.
well, yeah, we talked about it the first day when we were talking about
Very good. And Esther, what is the law of nature? What is this concept? I think I called in the same row for the same question last week.
Basically, they make their own rules. They don't.
Who's they?
In this case, the explorers, they make their own compact.
Well, wait a minute. So let me ask you this question, right? You know, they're living in a society, Newgarth, right? Newgarth has laws, statutes, etc. We're not talking about a deserted island, castaway, Tom Hanks, right? We're talking about a country that has laws. Why do the laws of this country not apply inside this cave?
So you're saying that since they made their own compact with the guys, it doesn't really affect their laws, can't really apply.
So Natalia, you and I are in Houston right now, right? Can we go make our own compacts, say, screw this, we're under our own laws, we're gonna start killing each other for food? Can we do that? Okay, everyone in this room, we signed a compact right now, we're in our own country, right? We're in Houston, can we do that?
No, because we're in a society.
We're in society, were they in society? Why not? Yes. Okay, this is Foster's point. He says they were beyond the reach of our laws, right? We couldn't get to them, they couldn't get to us. Our laws had no effect. So even though they were within our jurisdiction, right, within our country, they were might as well be in a different world, right? They were not within our jurisdiction. He makes some joke about, like, could they have been served process, right? Could a process server reach them while they're in the cave? Yeah, good luck. Could they be reached? So he says, look, this is basically a state of nature. They may as well be on a deserted island. And because they're like on a deserted island, they can make their own compact. And they made such a compact, right? Edwin, what was the compact they made? What was the agreement they reached on this deserted, cave?
The agreement was that basically one of them had to die so the other one could survive, and they would decide based on the role of life.
Did everyone agree to it? Did everyone buy into it?
At first they did, but then one of them backed out, but then
So it was just a breach of the social compact, right?
Yeah.
Can you breach a social contract? Can you pull out of a social contract once you agree to it?
Not really. No.
Well, says who? See, you're applying contract doctrine. Does contract doctrine apply when you're breaching a social contract? So really, what are even the rules that they agreed to? It wasn't well developed, wasn't well thought out. But what Foster's point is, we don't have any jurisdiction because they were not in our society. He writes, it's in Latin, but it means in English, when the reason for the law ceases, the law itself ceases, right? There's no more reason to apply our standard law. So our murder statute has no place in that cave. Our murder statute has no place in that cave. It's beyond our jurisdiction. He writes, it's as if this murder happened across the border in another country, right? We could not prosecute a murder that takes place in Mexico. We can't do it. Our laws don't go there. He was in the exact same fashion. The only law that mattered at that point was the law inside that cave. Okay? As a result, the dismissal, the conviction must be dismissed. So I'm going to get Foster 1, that's the state of nature, that basically they're on a deserted island by themselves. Yes, sir, Matt.
Isn't that still possible if they get together and they agree on set terms?
Yeah.
And they pause it?
Yeah, they made a positive contact, exactly right.
So then how would that be natural law?
I think I said state of nature more than natural law. They started in a state of nature, they made a social compact. Although, I mean, if you want to talk about natural law for a minute, the first principle of natural law is survival. And we find a way to survive by eating each other. Right. All right. Who am I up to? Is that Marcos? Marcos, Foster number 2, right? The guy's schizophrenic, makes a totally different ruling, right? You wish you did this on a paper. Well, I think this, but forget that. Figure out how to do this one now, right? Reject everything I just said. Forget everything. Marcos, what's number 2 for Foster? I'm sorry?
I don't remember number 2.
Did you read it?
I skimmed through it.
Okay, so just tell me you didn't read it. Skimming's not enough. Okay, I'll come back to you. Andrew?
Yeah. It's Andres.
Oh, I couldn't see the end of I made an educated guess, but go ahead with walking in.
I also couldn't read it. I tried reading in the morning, but your website wouldn't upload, so sorry.
Did anyone read it? Did you read it? What's Foster 2?
I have Hayden and Keys, and I don't have Foster.
Not happy. I can't see your name tag. Yeah, Khadija. What's Foster's second one?
The second one I
And just use a darker marker. It's really hard to
I
read.
lost my other one.
Yeah, if you forgot, I'll let you write later. Yeah. So what's Foster's second analysis?
It goes back to the purpose of the statute. So he was saying not so much as like the literal meaning of the statute, but what
Good.
the purpose is to achieve.
Good. So, in his mind, what's the purpose of the murder statute? Deterrence, exactly right. You say deterrence or deterrence in Texas?
Deterrence.
I say deterrence, and I'm weird. Whatever, deterrence, fine. He says the purpose of this murder statute is to deter people from doing bad stuff. But Zach, if you were about to starve to death, would this murder statute deter you from killing someone to eat him?
No.
How come?
Well,
One at a time.
I mean, just, it's either death or whatever the alternative.
So you'd rather risk eating now and maybe getting convicted later?
Yeah, right.
So what the court basically says is, if you're stuck in a cave, this is not going to deter you from killing someone, this statute, right? The fear of hanging, of execution. Because you're going to die. So you either eat the guy now and maybe survive, or you don't eat him now and you die. Or maybe you get eaten, right? If you're the guy who won't join the game, you're probably the one who gets chewed on. I think of the baseball video we watched 5 minutes ago, right? Like that's about as close to state of nature as you can get, right? Where like there's a really expensive thing that flies into the stands, and these guys are going at each other and knocking and wailing on each other. Fortunately, no one started to bite. Oh, I actually bit the guy. So I guess you do become these natural animal instincts. But anyway. Foster in the second part says, this is a legislative oversight. The legislature would not have wanted the statute to apply here, so as a judge, I will read an exception into the law, because this was not the purpose of the law. This is not what murder is. Right? You often hear this phrase, it's within the letter of the statute, but not within the spirit of its intentions of the makers. He says this is not within the spirit of the law. Okay? It's within the letter, but not the spirit of the law. Okay? So any questions on the Foster 1 or 2? Oh yes, sir, Matt.
It says that in Foster, it says that whenever coexistence isn't possible, that's what gives you the right to, I guess, more positive law or society law. So it's, I guess we can talk about that later, but is that part of the equation? Or?
Well, what he's saying is that when we don't have society, our own civil society, our laws simply are inapplicable. And that allows men to start making their own compact, which was this game of craps, where I guess if you lose, you get craps, right?
So is that more about being secluded or just having limited resources?
It's not limited to seclusion, right? His mind, even if there is less seclusion. Well, let me ask you this question, Matt. How many days must you be removed from society before you can enter a compact with each other? 30 days, 5 days, 10 days?
Based on what resources are available.
So it's only when you're about to die, only at that moment, you become subject to the laws of the jurisdiction. What if they'd waited another day or two, or if they had done it a couple days earlier? What if there was a possibility they could have been rescued but wasn't guaranteed? See the point, right? The difficulty of saying is, well, they're removed from society so they can write their own laws. At what point are you removed? How far away do you have to be? How many days to death do you have to be? There's no good line here. Are there questions on Foster 1 or 2? Yes, Megan.
Do they take into account at all the mental state to decide whether or not they were in a state of nature?
What do you mean? Mental state?
Like, obviously, with no human just wants to eat another human, if they were like in survival mode, so does their mental state have any weight on whether or not they were? I know it does in criminal law.
Well, actually, we'll get to intent in a minute. We'll actually get to intent in a minute. I think that's one of the next opinions. I'll come back to it later, I promise. So any questions on Foster? All right, let's do Tating. Is that Lucas? What did Judge Tating do? This was a weird one.
He basically criticized Foster on both his...
Oh, he did.
I guess rationale. So the first one he was criticizing about the state of nature and the state of society.
Yeah.
Civil society. And he basically was like, I'm not clear why. Like, was it a rock
Yeah.
He's like, were they out of our jurisdiction?
Yeah, what put them beyond our laws exactly? There's not a good answer there.
Exactly. And then he goes into saying that how's the PAT, or the contract.
Yeah.
And basically, when Whitmore made that contract, he made it irrevocable.
It was an irrevocable contract, right? Yeah, yeah.
And then he was like, Foster failed to see that the withdrawal from that contract. And it's like, was it, I guess,
Did you sense a little bit of sarcasm in this opinion? Why do you think he's being so sarcastic? Marcelo, you don't think it's that? Why was he being so sarcastic?
Because the argument that he's making, that Foster was making, both were, like, out of, mostly, I feel like Katie didn't even want to answer, I feel like he wanted to withdraw from Katie.
Well, we'll get to the withdrawal in a minute, but why do you think Tating was so critical of Foster?
Well, we didn't agree on, like you said, the first point, but also like his deterrence argument. It was, he said it would, it's a poll to assess, like if Whitmore had shot them for self-defense
Right.
instead, then.
Right. So the difficulty, and I think Tating points to that well, is when do you enter the state of nature, right? At what point do you enter? When do you leave? Right? Is there a bright line test? How many days do you have? And the second point is how insane it is applied to this contract theory, right? I mean, duress? Hello, right? You're about to start to, can you make a contract from such duress? I don't know. Do we apply the restatement second to this cave about life and death contracts? Can you make a contract for food? I guess under the UCC, are you a food service? You're a product? I mean, I'm being deliberately facetious, but there's a difficulty of applying the social compact theory. And also the point is, if the legislature wants to carve out an exception, that's for the legislature, not the courts. But the bottom line, though, is that Justin, what's the bottom line of Tating? What does he do here? What's his basic bottom decision? Does he join one side or the other?
He withdraws.
He withdraws. What the hell does that mean?
Well, he talks about struggling between kind of weighing the decision making on both sides, because talking about like directing men to be put to death when their lives are saved by the cost of 10 other men, as well as kind of like letting them go scot-free from murdering.
Yeah.
So he can't balance his kind of emotional.
You can't do it.
Issues with what the decision should be.
He can't do it. Right? He cannot do it. And later on, he comes back and says, yeah, I still can't do it. So Samantha, what's the consequence if the case splits 2-2?
Basically, he says that regardless, with the whole, like, going back to the deterrence purpose of the statute, even if you do hold convictions, it's not to say that this will deter the same thing from happening in the future if you put these people...
You're right, but the question here is, what happens if the Supreme Court splits 2-2? What happens to the 4 guys? What happens to their conviction and sentence of death? It's upheld. This is the rule. When a court of appeals ties, the judgment below is affirmed. When the U.S. Supreme Court splits 4-4, and it happened a couple of years ago, you affirm the judgment of the lower court. So their death sentence is affirmed. So Samantha, even though Tating's withdrawing, what is he effectively doing? He's allowing them to get hung. Hanged, hung, I never remember, right? He's allowing them to get executed. By withdrawing, he is allowing the execution to proceed. So he's not so innocent there. Pardon the pun, but he's not so innocent. Okay? Alright. Let's go on. Kelly, what's Justice Keene's analysis?
So Keene starts out by saying, as a citizen, she would pardon these men altogether.
Okay.
But then says that they need to follow the statute, so execute the 4 survivors because they killed another person and there's no mystery about it. So the legislator can rewrite the laws if they want to, but we need to enforce what we currently have.
Yeah. He says, look, there's no exception here. Murder is murder is murder. We can't read some sort of purpose into the statute. We can't concern ourselves with deterrence. This is a case of murder. He also responds to Tating And he says, look at this, right? Courts can't do this. Okay? So Tating will say, follow the statute. Those guys get executed. Okay? And then we get to, I think, what's most humorous of the opinion. The last one, Handy. Dylan.
Handy was like, he said he thought it was like a pretty easy
Yeah,
solution.
a piece of cake. Yeah, piece of cake.
He said that
Just
like
for the lulz,
because
right?
everyone in society would have agreed not to hang these people.
How do we know that? How do we know that everyone in
they took
society
like
would agree not to hang them?
I think they took like some sort of like a poll, I think.
Yeah.
Yeah.
You ever see this before, right?
Yeah.
They looks at public opinion polling to find out what the judges should do.
And he said that because everyone agrees, like, what's the point of even having this like argument? And we should just let them live, I suppose.
Let them live, let them live. Well, he goes even beyond that, though. What does he say is likely going to happen here? What does he know here? What does he think will happen here so he's not so worried? Or maybe he is worried. Lance? What does he think is going to happen here, one way or the other?
That the chief executive will not.
How does he know the chief executive won't pardon the guys? This is my favorite part.
He's heard a rumor.
Yeah, from where? Right? Who's got it?
Didn't he like have like some connections with people? And
Yeah.
they were, like,
Ready?
got really
My
bad.
wife's niece is the friend of the executive secretary. That's like quintuple hearsay. Okay? My wife's niece is friends with the secretary of the executive. And he says that she said that he said that she said there won't be a commutation. So the consequence is, unless the court lets this guy out, they're going to be executed. So as a result, he says, I vote to acquit. I reverse the conviction. Tating is asked to give a do-over. Okay? Tating's asked to do a do-over. And doesn't change his mind. So what happens next? It's a 2-2 affirmance. I'm sorry, it's 2-2, so it affirms. And the execution is scheduled. All right. Let's see the results. I don't know. Let's see what people put. I don't know. Let's see. So the most common ones actually. Hold on. If I can set one screen. Okay. So the most common one is Foster 1. That's interesting. Actually, I'm sorry. The most common one is Keene. Okay, so most of you say follow the statute. All right. The second most common one is number 3, which is Foster 2. Purpose. Okay. Why am I? What's going on? Are these jumping around? They're not sorting by.
No.
Oh, that's why I'm not reading it. I was reading them in order. So. There we go. Okay, so the first off. Yeah. God, this is not working. Is it? Okay, there we go. So at 30% is Keene, follow the statute. Okay. At 26% is Foster 1, that's the state of nature. And the rest of them are about equal. So most people say either follow the statute or state of nature. Alright? Let me run this one again, see if you guys change your mind. I'll put the options back up. Let's try this one more time. This one I'll give you a full minute, but see if numbers change at all. I don't know if they did or if they did. Seconds. we got? Alright, so results. Alright, so I should put them in order. So, let's see. Still the most popular is Keen. Okay, so now Keen was 30%. And why is it puts these in these bizarre orders? This is so strange. I'm jumping around. Keen was 30%, now it's 45%. So most people say just follow the statute, let the guys hang. Yeah? I do have to ask, who selected Judge Handy? 6 of you had selected Judge Handy. You don't want to defend that one? I don't. It's not wrong. They're all in there. A lot of judges take consideration of public opinion, just don't say it out loud. A lot of judges do this exact sort of thing. I want to talk about Judge Handy. No one. I can check who you are, but I won't. What's your hand? It's no fun.
I picked Judge Handy.
All right, yeah. Be honest. I know lots of you out there.
You said it was a fictitious world, so I took this as my opportunity to be a rebel.
Okay, I like that. I like that.
I chose to go with what the
So you
public opinion.
think it's a good idea for judges to just look what people want and do that?
I'm not saying I necessarily think it's a good idea in all circumstances.
Okay. All right. Rachel, you want to give a Judge Handy?
I didn't choose him in this, but when I was reading it, I was between Foster 1 and Handy.
Really? Okay.
I think that since they didn't have a jury decide this, looking at public opinion is very similar to what a jury may have decided.
So is there a difference between a jury of peer find versus a public opinion poll? Which is more accurate, in fact, 12 random people or a general survey of the public?
Depends on the information that they're getting.
Oh. Who else? Anyone say is it Handy? Yeah, Marcel?
I chose Handy based on his decision based on Foster 2, not based on public opinion. Because I agree on Foster, just not the decision judgment, but I agree on the deterrent, like purpose of it. So that's and I think that is practical common sense. You have to base it on some legality.
So judges should just use common sense. Look, is that so dissimilar from what the judge did in the whale case earlier today? Right? Is what Judge Handy did, I mean, they made it exaggerated, right? For sure it's exaggerated. But is that any difference in the judge in the whale case? He was citing the custom of what whalers did. Julian, you want to add something?
Just that there's no precedence for this. And so getting an opinion of the people would be akin to finding out what the custom of the society is.
But there's a difference. What's the difference between the whale case and this case? What's the big difference? It's a really big difference.
Murder? It was mine.
Well, the whale was killed versus the guy was killed, so there's death. But what was lacking in the whale case that exists here? Very important thing. Yeah, Harrison?
There's a statute.
Statute. Are we in a common law world, or are we in a statutory world? And think about if it makes any difference from your point of view, whether you're dealing in common law or statute. There's a legislature here. They could have drafted the statute differently if they didn't. They drafted it this way. Now, legislatures are not perfect. They can't think of all various ways where the statute will be applied. For example, in a cave with cannibalism. Okay? They went with Tating, the one who withdrew. Yeah, Josh, go for it.
I like his explanation mostly of the laws of nature and how that
Rejecting it. Yeah. Did you agree with his decision to just peace out and not decide the case?
Not particularly, but did the end result that I wanted to explain?
Oh, so you think he withdrew to get the guy executed but didn't really want to say it? Is that what you think?
That's how I felt.
Anyone else Tating want to withdraw? I know about 5 or 6 of you put that. Yeah.
I put Tating originally. I liked how he talked about, how Foster commented about the law of nature. They're not in our society. And Tating came back and said, well, no, he used the person in the cave turns 21. And it was just because he turned 21, does that mean absolved? If he turns 21 in the cave, does that mean that the laws don't apply to him in the cave and he can't still,
Anyone else want to chime in? Anyone else? Whichever one you pick, doesn't matter. Just spoken yet. Yeah.
I couldn't remember if anyone had mentioned this in any of their opinions, but I definitely agreed to set aside the death of these 4 guys, because it's almost like a waste of those 10 lives that died to get them.
That's a good point, and that fact was put deliberately in the fact pattern, right? 10 people died to rescue these 4 ingrates, right? While they're having a dinner party, right? People try to rescue them, and they die. So you think your execution is justified based on these 10 innocent men who were killed?
I don't think executing them is justified based off their death. So like, because those 10 men died, you're just gonna kill 4 more.
So you think that's a reason not to execute them?
Yeah.
Oh, I thought you were saying that, you know.
No, like, don't kill. 10 men have
not
already
bloodshed.
died to kill these
11.
people. So why don't we just get them out and then kill them ourselves? Like, why don't we just kill the 10 men in the first place, just ourselves, and let these people starve in the cave?
Edwin?
I mean, basically, like, I guess like the dead guy would be like, they kind of killed him for I would side like with the dead guy because like he was kind of forced, even though he agreed first. He was
Guys, just one at a time. Only one person talk at a time. Okay, go on, Edwin.
He was forced to participate even though he had withdrawn already. They rolled dice for him, so like the statute would clearly apply like for them, like I guess to give him justice.
So which judge did you pick?
I picked number 5.
You picked number 5. What was number 5? I can't remember the number. You have to follow the statute. Yeah, hang them. All right. Anyone else? Yes, Ari. No, Ann. I know.
I just want to point out that Keene is logically inconsistent. He says that we have to follow the law, not morality, but then he goes on to say, yes, but we can talk about the purpose because primarily such a statute reflects a deeply felt human conviction. So he's saying we have to follow the law, not morality, but then he turns around and says, but the law is based on morality.
Oh.
So he's inconsistent.
So judges aren't always consistent, what you're trying to say. All right, anyone else? Yes, Leslie.
I chose foster 1
Yeah.
because the moment that they reached out and asked for help from the doctor, or like they asked their opinions for the doctor and the judge and everything, kind of felt like they're like, society's not helping you out, or like the laws are not helping you in that.
Self-help, right?
Exactly. So they, especially when she said the mental state kind of went back to nature where they were so panicked and they're like, okay, it's either we die right now or we die in the future, and they abandoned us even though they were trying to rescue them, but they basically abandoned them because they're like, we're not going to tell you what to do. A judge or somebody official could have said, hey guys, don't kill each other because it's murder, you are going to be punished. Simple, but
You should have asked for a lawyer instead. Yeah, Christina.
I was just going to say, and this relates back to a case we already read, but why didn't they just wait for somebody to die and then...
You can't eat a corpse, it's sick. Yeah.
How do you know that?
Right. If you can't eat a dead animal, it's dead for a reason because it's sick. It can actually kill you by eating it. So you have to just eat live flesh.
Haven't you ever seen Walking Dead?
All right, calm down. One at a time. Yeah, I only have one rule in this class, but then one person talks at a time. If you talk over someone else, it's very disrespectful. Just one at a time, and we'll keep it like that. But yeah, you can't eat dead flesh. I mean, your idea, I guess, would be smarter, but once person's dead, you can't eat it anymore. Thank you for the question.
Are they sick though when they die?
Yeah, there's a reason why a person's dead, and you can't eat
They
it.
just didn't eat, so...
There might... You die because of organ failure. Right? That's actually why you die. There might be some toxins flooding in your body that you would not want to eat. Your kidney might go, your liver might go, various things start leaking, and you don't want to eat that stuff. Bile. Google this. It's not anything else? Anyone else want to talk about this? So, okay, so 2 more though end of Pierson. Yeah, so Mike and then Justin.
Going along the lines of what Christiana said, but instead of killing or waiting for somebody to die, why did they not just take off a limb off of each other?
Because you
off of living limb. Well, assuming somebody could survive.
No tourniquets. All right, Justin.
Like, I think
last one. I'll move on.
A lot of this could have been avoided if they just. I mean, I think that like it glosses over them charging them in the first place.
Good point. I want to flag that, right?
Because I feel like it's such an extreme situation that lacks like any sort of case law or any sort of.
So first off, the decision to charge them at all, right? But why can they be charged with eating human flesh?
Because there was no statute for that.
Why can they charge with battery? False imprisonment, right? There are other far lesser crimes it could have been charged with. So the decision of the first incident of the prosecutor to go after them was very significant, and I think that's referenced in a couple of the opinions. All right, Counsel, I'll go on because we're running a little bit short on time. I don't want to keep you that much later. Why did I assign this case for you? Hackman, what are you doing? This is crap, right? No, the reason why is that the sorts of frameworks used by these judges directly implicate how judges decide all cases. And I want to bridge this to Pierson, right? So, Truepenny, right? Justice Truepenny said, we have to follow the law. But I don't like the result. Right? Keene said, well, you murder him, right? You know, not fair. Foster 1 said, well, it depends. What sort of arrangement was reached? Foster 2 said, well, it depends. What's the purpose of this law? And then Handy says, well, you know, let's just look at what people do. What's the custom, right? What's the public opinion? And then you have court tating, like the judge in the Papa Hayashi case who couldn't decide the damn case. Like, I don't know, you got split up, whatever, right? I'm going to show you by the end of this class how the judges in Pierson post map onto that very carefully. So let's go into Pierson. Were any of you in my mock class on the first day of law school, the orientation? Anyway, I always do the orientation. I always do this case for my orientation class, so I can't remember if you right there. Who's next? Where am I? Okay. Alec, you want to give me the facts, please? And Pierson v. Post. This, by the way, is like the most famous law school case forever, right? This is the case. The purpose of this case is to indoctrinate law students. Long after you're done with me, you won't remember my name. You won't remember anything I told you. You remember the Fox case. Trust me on this. Everyone remembers the Fox case. This is a seminal moment in law school. So, Alex, what's the Fox case? What's
All right, so it involves Pierson v. Post. Post was hunting a fox and was putting all of the workings, basically like the labor theory.
Very good.
Putting himself and chasing the stocks. And so Pierson saw him putting all this work in and just decided to kill the fox and take it.
Yeah.
And Post brought suit as a trespass.
Good.
And said that he trespassed on his fox. And the lower courts found him in favor of Post, and which Pierson appealed.
Good.
And basically, it comes into the fact of like who had ownership of the fox.
Very good.
And so it goes on by saying, is pursuit enough? If they, basically, like I said again, labor theory is like, is putting in the work for the animal enough, or is having the animal itself enough? That's what brings it into the judicial.
Okay, very good. This is the classic rule of capture case, right? So what happened? Post was tracking a fox with his hounds in an elaborate hunt. Pierson, who was aware that Post was hunting the fox, intercepted and killed the fox. Post was not happy about this, and he sued Pierson. As it turns out, we have the record in this case, they hated each other. There was a massive feud between these two guys. This lawsuit was not about the stupid fox, right? The amount of money they spent on lawyers far exceeded the value of the fox. This was about a personal grievance between these two guys. Okay? So there are two opinions. The majority opinion by Judge Tompkins ruled for Pierson, the jerk, because the jerk actually captured the fox. The dissent by Judge Livingston found that Post had the proper claim to the fox because of the labor expended during the hunt. Alas, Post, the hunter, was out of luck, even though he invested the time to track the fox. So what's the moral of the story and the black letter rule? It's the rule of capture. Possession is obtained through physical occupancy. And again, a fox is a sort of animal you can physically grab. This is not like a whale, where you have to shoot it and hope it floats in the water. Or a hive of bees, we have to mark the hive. Or a bird, we put a little ring around its foot. Right? A fox you can legit catch. I have a stuffed fox in my house. I forgot. I usually bring it, but I forgot today, so I apologize. You can go see it later if you want. Now, this case was decided at a unique time. We're in 1905 in New York. This is, maybe 30 years after independence. Is that Stephanie? Stephanie, were there any statutes or common law principles that govern this dispute? No, why not? Yeah, this is a fairly novel concept. Hadn't happened. It's a birth of a new nation. Oh, did I mention the Hamilton thing? So there's an incentive in place for the highest scoring midterm. Hamilton the musical is coming to Houston in April. I have a ticket for the highest score in this midterm. So I'm a subscriber, so there are 4 tickets. I gave 2 to my midterms from last semester and 2 to my midterms. So you guys one and Kamala gets one. So the highest midterm gets a ticket.
Wow.
I already saw it. I saw it on Broadway, so I'm good. But that's your incentive. So anyways, as I say, it's a birth of a new nation. I actually wrote an article on Pierson Post, and I cited Alexander Hamilton's manual. When Hamilton was studying for the bar, he wrote this like manual of law, which is like the perfect summary of New York law in the 1800s. It was an amazing document. I actually cited it in this piece. But at the time, there were no statutes. There's no common law. Why? America had rejected the British common law. They just said, screw you, we're a new nation. So there was this aversion to citing cases, right? They could have cited the Duck case, right? They didn't. The Keeble case. So, is that Rachel? Rachel. So, because they couldn't cite any statutory law or any common law, what did the judges turn to? What sort of sources did they cite?
Just kind of like the law of sportsmen of hunting.
Well, before we get to laws of sportsmen, what sort of sources did they cite?
Institutes.
What's institute? What is this? Justinian. Who the hell is Justinian? You're exactly right. Who is this guy? Harrison, want to take a step? Did I skip you?
Yeah, you did.
Oh, I did. I'm sorry. If I do that, tell me. I don't always remember where I am. All right, you're next. Okay, Harrison. So who's Justinian? Who are these people?
They're like philosophers.
They're philosophers, right? Justinian was this Roman scholar who wrote this, an emperor as well, but he wrote these digests, which were these very thick books of code, the Roman law, the Roman civil law. The court also cites various natural law writers. Pufendorf and Grotius, right? We talked about these guys last week. It sounds like a Harry Potter school, but Pufendorf and Grotius were theoreticians on the natural law. Judge Lip, you okay there? Judge Livingston in dissent cites another philosopher named John Barbarac, who was a disciple of John Locke. So even though Locke is not cited, which is strange, the dissent of Livingston is basically based on Locke. Okay? But even though we're citing all these natural law philosophers, they don't all agree on the correct rule. So Kendra, what is the rule that Judge Tompkins adopts from Pufendorf and Grotius in the majority opinion? What's the rule there?
So doesn't it say that actual bodily seizure is not the right to it? It's if you morally wound them.
Well, no, the majority I'm talking about.
Is that not the majority?
What does the majority require?
I thought that was it. But I guess not.
Is pursuit enough in the majority?
Yes. No, because they rolled with the other guy. So it's
Okay, try it again. So what's the rule of the majority?
You
What's the rule of the majority opinion?
physically possess them.
Yes. This is Hayashi's theory, right? You need to physically possess the entire animal. It's not enough to chase it. It's generally not enough to wound it. You need to physically have it. Mere pursuit is not adequate. Maybe if there's some mortally wounding, it's okay, but the truest way is not really to stop it in its tracks, but to kill it. This is like Hayashi and Pavlov, right? He stopped the ball from flying. Was that enough? Or did he have to actually capture it and stop it and fully control it? And again, because a fox is a fairly small animal, you can put it in your arm, right? You don't need like a boat to tie it to a cable, right? So the majority theory looks to Pufendorf and Grotius to say if you're able to physically capture it, that's enough.
Or injure it.
I'm sorry?
Or seriously injure it.
Yeah, the injury one's tricky though. They kind of hedge on that one, right? Because it's not presented here. This is not a case where imagine you shoot a fox and it breaks its leg and it's kind of hobbling along, and someone picks it up. You could argue that the wound was mortal, that you struck it but it didn't die right away, and that after it escaped, someone else can't swoop in. But they're very fuzzy on the wounding part. I think you picked up on that. It wasn't exactly right. Next, I can't see your name. Aaron. Yes, Aaron. Oh, yes, sir. Harrison. Yes, sir. No, you redeemed yourself. You're good. Because you gave me the Justinian. So, but I appreciate your candor. Aaron, what's the theory for the dissenting opinion? What approach? The majority's rule of capture. What's the theory of the dissent?
That they're more so like foxes are like a public nuisance, and so really by capturing it and killing it.
Well, we'll get there in a minute, right? That's right. But what general theory of law does a dissent adopt? It's not rule of capture. What theory? This is a biggie. We've only done a couple.
Yeah. Is it just by with the labor?
Labor theory, very good. Right. The dissent adopts what we now know as labor theory. They cite a guy named Barbarac, who I mentioned as a disciple, a student of John Locke, right? And the dissent says that if you invest labor in the pursuit, you get it. That is, you can occupy the beast without mancupation. Everyone see this word, mancupation? Did anyone bother looking it up? Anyone look up mancupation? Look at this word. What a word is this, right? Type it. Mancupation. God, what a word. What does that mean? Anyone want to tell me? What's mancupation? Please tell me someone looked it up. One of you. There are 8 of you. Yes, Kelly.
You must have the thing in your hand.
Yes, physical handling. Physical possession, right? Remember Hayashi holding the ball, right? That's what we call mancupation. He had the ball. He's like, hey, look at me, I got the ball, right? Mancupation. Imagine someone tackled him at that moment when he had the ball in his hand. That would have been even crazier. He was cocky holding up like this. I would have ran the hell out of there. Got out of it as quickly as possible. Anyway, so the dissent says, under this theory, mancupation is not required. Pursuit was sufficient. Okay? So let's now analyze these majority dissenting holdings, right? Sutra, what's the biggest weakness of the dissent's holding? Biggest weakness of the dissent's holding? What's the easiest criticism to lodge against the dissent?
Uncertain.
Oh, you're exactly right. Why is the dissent very uncertain?
Because the pursuit, I think we talked about it earlier in the other class, but the pursuit can be, like, you may not have put in as much effort as you think, and the court may not recognize that.
How do you know how much pursuit you have to put into it till you get it? Right? Chasing it for 1 hour, 2 hours, 5 hours. How many dogs do you have? The big dogs, little dogs, right? Did you really try hard, or are you phoning it in? The biggest criticism of the dissent is it's hard to measure. It's not very certain. It does, though, have a fairness to it, right? Joyce, why is the dissent's approach a lot more fair?
Because you put in the work, so you should have.
Good. Keep going. What should happen to the person who puts in the work?
They should essentially just get what they put in the work for, because they worked hard.
They're rewarding.
Yeah.
People put the hard work in. That's exactly right. They're rewarding them. The downside, though, of the majority opinion is, Madison, what's the downside of the majority opinion?
It's unfair.
Yeah, you're rewarding the jerk, right? This guy came at the last minute, swooped in, killed the fox. You're rewarding the jerk. But again, what's the advantage of the majority?
It's certain.
Okay. Why is it certain?
Because you can prove and
Yeah, Mr. Hayashi. Yep.
emancipation.
Yeah, the ball, exactly, emancipated the ball. Okay, so the majority and the dissent have very different approaches, right? Gabriel, I think we'll go to you now. What's one of the other grounds on which the dissent ruled, right? Why do you think, let me ask the question differently. Do you think Judge Livingston in dissent really cared about Roman law and common law and Locke and Barber? Do you think he actually cared about any of that crap? What was motivating his decision? Why did he actually reach the decision he reached?
Because he goes into like whether or not like he was able to see the person hunting with his hounds and whatnot, and whether or not he had just intercepted the fox.
Let me ask the question differently. Why do you think the dissent was motivated to give the fox to the hunter and not to the jerk? What was actually motivating him right there?
Just because he had been scavenging all day.
Lauren?
Because it was more fair.
Well, beyond fairness, what else is the reason why the hunter should be rewarded here?
You put in more work.
What else? You already said that. Austin?
Promoting the hunting.
Ah, promoting the hunting. What do you mean promoting the hunting?
It would discourage hunting.
Ah, this is the whaling argument, right? If you give the fox to the jerk, you're going to disadvantage the hunting industry, right? People won't want to hunt if they're not guaranteed to keep their fox. Now, I can't remember what I said before, the whaling. Is it actually going to discourage whalers? Probably. Do you think any hunter will stop hunting because of this case? Of course not, right? There's also the point, the idea of the fox hunt is a very aristocratic notion, right? I think I got some pictures of it up here, right? It's very aristocratic. You have these, regal people on horseback, running around like Downton Abbey, right? There's, this aristocratic thing. We had the birth of a new nation, right? We didn't have aristocracy here. Constitution prohibits titles of nobility. What was the primary concern then about foxes, Daniel? What was more important, the regal fox hunt or what else? Extermination. Yeah, getting rid of pests. Foxes prey on chickens, right? Foxes prey on chickens. They're bad. So the majority's holding, right? I'm sorry, the dissent's holding is saying, look, let's focus on getting rid of these chickens, not these regal hunts. There's a little bit of a tongue-in-cheek there. The dissent is very sarcastic altogether. All right. So Michelle, let me ask you this question. We have these two rules. The rule of capture for the majority has its pros and cons. We have the labor theory of the dissent, has its pros and cons. How is a judge to decide which rule to adopt? Because again, there's no statute here. There's nothing binding. There's no common law precedent. How is the judge to decide what to adopt?
I guess it just depends on the circumstances.
Oh, you have to be better than that. I know you want to adopt with that one, but I'm not going to let you off on that one.
Oh.
How do the judges decide? What's motivating them to pick one or the other? What's motivating them?
Maybe what the majority of the public.
Oh, you see where I'm going with this, right? Leah, you see where I'm going with this? What are the reasons why in a spelunking case different judges reach their various different conclusions? Oh, okay, I see the wheels turning now. I'm bridging the two together. Anyone want to try this one? Yeah, Brandon.
Morality.
Morality, okay. Yeah, James.
Aren't they appointed? Don't have political affiliation sometimes?
Well, is a Fox case political?
It could. You just talk about it, it's very
Maybe, Megan?
Like precedent, what will affect society in the long run?
Oh.
I like the.
No, raise your hand, please. Yeah. Yes, go ahead, Anthony.
Kind of like, just going off of what they were saying, kind of like the greater good, even though yes, wrong was done, ultimately, hey, no killing chickens, right?
All right, let me try this, and I'll wrap up in a minute, so you have to go at 5, you can leave shortly. The reason why judges rule the way they do is not political. I mean, maybe it is sometimes, but I think that's not the case. I think judges bring certain first principles to their position, the things they value, right? A judge who privileges fairness is more likely to pick the labor theory. A judge who promotes and favors certainty in the law will pick the capture theory, right? So let's go back to our judges in this Speluncean case, which we discussed earlier today. Judge Truepenny, right? He said, follow the law even if I don't like it. What does that mean? The jerk gets it. I may not like that Pierson gets it, but that's what the law requires. So some judges think, you know what? Follow the law wherever it leads, even if it's not fair. Okay? Keene says, follow the law, too bad, doesn't matter, right? We're not going to craft any sort of exception about pursuit. We say straight up, mancupation is required, and there's nothing else. Then you have Foster 1, right? These guys were on a deserted beach. There was no law requiring them. What sort of compact would they have actually made? Do we follow the rules of hunters? Do we follow the rules of the Romans? Do we follow the rules of the British aristocracy? Right? What law do we pick? What about Foster 2? What is the purpose of this law? Is it to promote the hunt or to encourage extermination? Right? If you're trying to promote the hunt, then you give it to the hunter. If you're trying to promote extermination, you give it to the jerk whoever killed it first. And you have poor old Judge Handy. Public opinion? Ask the sportsmen what to do. Submit it to their determination. It's not for us judges to decide. And then invariably you have Judge Tating who couldn't decide at all. But the sorts of modalities, the way the judges decide about certainty and fairness, will pervade basically everything we do throughout this semester. Okay. That was your summary. Questions on Pierson or the Speluncean case? Yes, Kendra.
So then, is it for animals that you can possess? Is this the rule of the law? But then animals.
There are several rules for animals.
So it just depends on like what.
You gotta know all the cases, my friend. You gotta know the whale case, the duck case, the fox case, right? And we'll do some cases next week with oil and gas and other things. So these cases aren't entirely consistent, which you'll find in this class. That there's tension, and you need to know how to apply different cases in different contexts. You're welcome. Yes.
Which justice did you agree with?
I like Foster 1. I think it's very difficult to apply our rules to a scenario where the laws simply don't apply. I was in law school. I did the same 1 year ago. I'm still at Foster 1, I think. I go back and forth. Usually I do Foster 1.
Back and forth between that and what?
Foster 1 and Keene. Yeah, I go back and forth. Yes, ma'am.
I was wondering about Pierson.
Just let her finish her question. It's very rude to pack up when someone's speaking. Yeah, go ahead.
I know in notes it stated that there was actually a custom in place for sportsmen, basically the chaser.
Yeah,
gets
that's
the
it.
animal.
Right.
So why did the judges not apply the custom?
Well, what prevails? Custom or Roman law, right? Why did judges think Roman law was more important than what sportsmen did? It's, again, what sort of sources the judge find persuasive? Old stuff that people are long dead, or people are doing today. The difference is, the stuff that's been written around for hundreds of years is in a book, you can read it. The custom sportsman is not really written down. How do you know what it is?
I mean, it could be like how they did in the whale case.
Oh.
You know,
The whale case went straight custom, yeah.
Right.
But see, they're different. These judges take different approaches.
Right.
Thank you. Anything else? Thank you for the marathon. I will see you on Tuesday.